report, it is the one that is being debated. The one we tabled here from JLAC has not been acted on, it has not been debated, and we think it has actually met its natural death. However, the points in there are important, especially for those who had dissenting opinions, because they would be able to actually voice those opinions as they debate this particular report.
Thank you. So, for the purpose of this debate, I would allow members who are inclined to refer to that earlier report to do so. Because from what the chairman has said, this report you're debating today is a product. Because you said yourself that you harmonized. And the harmonization was based on what you had presented to Parliament. So, and I've read this report pretty quickly, and for example, the dissent, if you have to call it that, by the Honorable Saib, the Honorable Kajuang, the Honorable Muma, are captured in this current report we are debating. And so I don't think there will be anything patently wrong with any member who wishes to refer to the original NADCO report to do so. The Honorable Ekomas.
There was a point of order. Thank you, Mr. Speaker, for the opportunity to second the report that has just been ably moved by my chair, the Honorable Murugara, which is the joint report of the National Assembly Departmental Committee.
The Honorable Muhia, just get your card up and then you come and put it here. Then I'll give you your point of order. Just get your card up there. There's people there, there's staff over there. Just go there, get your card. You come and put it, and then I'll give you a point of order. That is the procedure of the House. You know that very well.
Mr.
No, not quite. Everybody speaking in the House, and you know it. These are our rules, the Honorable Wanjiku. Just order. You are directed to go to you don't have the mic, obviously.
Mr. Speaker, if you allow that, I may continue seconding the motion.
Just go up, get your card, you come back, I'll give you your point of order. Go ahead, Honorable.
Mr. Speaker, thank you for the opportunity to second the motion that has been ably moved by my very able chair and senior, the Honorable George Gitonga Murugara, being the report of the Joint Committee of the Departmental Committee of Justice and Legal Affairs and its equivalent in the Senate on the NADCO report. Mr. Speaker, my chairman has taken us through the historical background of where we are coming from up to the point where we are in terms of what transpired in NADCO, even from the beginning where we had the bipartisan team that was jointly co-chaired by himself and the senior counsel Otiende, and where I also participated. Mr. Speaker, I want to be very brief. One of the things that we did in considering this report, and I want to confirm the sentiments of senior counsel Otiende Amollo, is that there was seeming laxity by our sister committee in the Senate to attend meetings. And that prompted us to consider the NADCO report initially as a committee of this House without the participation of the Senate committee. And that is what produced the report that was tabled before this House in October. And I also want to confirm that in that report, we agreed on many of the issues, up to 98%. And a few issues, there were divergent opinions by the three members who the Honorable Otiende Amollo alluded to. And therefore, I don't think there will be, in enhancing our right to odd divergent opinions, our constitutional right to expression, I do not think there will be a problem in members being allowed to refer to the original JLAC report. One of the things that we have done in this report, Mr. Speaker, is to separate the constitutional amendments that require a referendum to be enacted from those that do not require a referendum. Because, Mr. Speaker, as you would notice, under Article 255 of the Constitution, there are different routes to constitutional amendments. One of them being parliamentary initiative, where you do not require to do a referendum, and the other one being the popular initiative, where you, on particular clauses of the Constitution, on particular articles of the Constitution, you require a referendum so as to amend. And one of the distinct amendments that we have brought before this House to recommend that it be processed through a parliamentary initiative is the amendment involving the National Government Constituencies Development Fund, the Govt, and the Senate Oversight Fund, for members of Parliament to be aware. And we did this because we do not want important issues that are of public interest to be lost in detail, to be lost because there are things particularly that may be poisonous and Kenyans may not want them. So we separated so that Kenyans may be able to choose that which they want and that which they do not want. Mr. Speaker, also, as alluded, we found difficult as to where to place the office of the leader of official opposition. Yes, we are aware that the political elite out there are clamoring, including ourselves, for the creation of the office of the leader of official opposition. But looking at it technically, there are three arms of government. There is the executive, there is the legislature where we sit, and there is the judiciary. And we were not able to place the office of the leader of official opposition in any of the three. If it is created as an office in the executive, we were asking ourselves, how will that person sit in the legislature? If it is an office in the legislature, how will that person enjoy the protocols of the executive and the trappings of power in the executive? And we also found that it will be a little clumsy to have both the leader of minority and the leader of official opposition sitting in the House. And we recommended that there may be possibly other routes to create that amendment. Mr. Speaker, because I notice time is not on our side, it is important to state this for clarity and for Kenyans to know that there was a proposal under NADCO to increase the term of the Senate from 5 to 7 years. And the joint committees to this one said a big no, that we do not want to increase the term of Senate, we do not want to increase the term of any holder of a public office beyond what is constitutionally stated. And therefore, Kenyans should rest easy, knowing that we are not going to increase the term of Senate, we are not going to increase the term of the National Assembly. It will remain 5.
Allow him to finish his sentence. And my advice to the clerks is that it's good to allow a member to finish the sentence they are on before you cut them off on the time.
Thank you for your protection, Mr. Speaker. Just to conclude, to say we have recommended that the recommendations on extension of term for the Senate be dropped and there not be any bill presented before any House of Parliament for extension of term. Mr. Speaker, with those remarks, I beg to second and urge members to read the report so that we may contribute and do justice to the people of Kenya. I thank you.
Thank you, honorable members. I now propose a question, which is that this House adopt the joint report of the National Assembly, the Parliamentary Committee on Justice and Legal Affairs, and the Senate Standing Committee on Justice and Legal Affairs and Human Rights on its consideration of the report of the National Dialogue Committee, in short NADCO, and the report of the Multisectoral Working Group on the realization of the 2000 Gender Principle laid on the table of the House on Thursday, 16th January 2025. The Honorable Karoli Omondi.
Thank you very much, Right Honorable Speaker, for this opportunity to speak on this NADCO report and the recommendations, which I note with a lot of gratitude that majority have been rejected. Because the first time I went through this report, I learned with horror that there was a proposal to increase the number of members of parliament so as to meet the 2/3 gender parity through further direct nominations. I firmly believe that we are a parliament of 290 elected leaders, 47 special seats by affirmative action, and 12 nominees. If you do your math, a third of the 290 would be somewhere around 87 plus. If you take away the 47, which are already affirmative seats, because you can't do affirmative action on seats that are already affirmative, and then you add to the 12 nominees, which I propose should be reserved to women, the shortfall would be something between 28, 29. That being the case, since all our political parties get direct public funding, we should make it a requirement. If I was in that group, this is what I would have recommended. I should have recommended that every party, to qualify for public funding, must meet the 2/3 gender rule. Because they have safe seats which they can reserve to women in their strongholds. They have. And we don't have to add additional seats through party lists. Even the concept of party list itself is an oxymoron in our constitutional system. Party lists are used where parties are elected, not individuals are elected. In South Africa, ANC goes to elections. It is ANC that is voted for. No individual is voted for. In Kenya, we have direct election of members. So in South Africa, they have a party list. Those who will become MPs if they win a certain percentage of the vote as a political party. In Kenya, we don't need a party list. It is a constitutional oxymoron. So I'm very happy that this has been rejected. And my proposal is we do not need to work our heads too hard about the 2/3 gender rule. The solution is already in the Constitution.
The Honorable Karoli, what has been rejected?
I am reading the observations of the committee. They are clearly saying these things cannot be implemented. I've read.
From what I've read in the report, they are saying they're supporting it, they're only deferring its implementation.
It has been rejected. Read the observations of the committee. The proposal was overly ambitious and would pose significant implementation challenges.
That is the proposal.
Yes, during the current term.
Order.
Yeah.
Because it's good to debate so that Kenyans understand what you're saying, the information. Yes. In this report, and Remo Mrugara, you can give us the page. The committee actually accepted
it is page 17.
The committee actually accepted that proposal. The only thing they're saying is overly ambitious is the proposal to implement it in this term of parliament. But in terms of the party list, the committee actually accepted that proposal.
Honorable Speaker, they are saying it was the committee's view that it would be neater to implement the proposal at the time of the current parliament. Yes. So anyway, whatever it is, the bottom line is, it is not workable. We already have a solution in the current constitution. All we need are about 87 fine ladies elected into this parliament, and 47 already have special seats. We have 12 reserves, slots that we should reserve for women, whether they are PWD or workers or representatives. And then the parties, because of receiving political party funding, should be made accountable. It must be a condition that to qualify for political party funding, you must have enough women in your party. So I am happy with whatever has been recommended here, but my understanding is that the nightmare...
I'll give you more time on this, Honorable Karoli.
Yes, please.
But I want you to read page 17, where you've referred me to, at paragraph 88.
Paragraph?
The same page, at paragraph 88.
The bill proposes to amend Articles 97, 98 of the Constitution. New clauses are inserted to provide that where after general election 2/3 principles is not met, the National Assembly and the Senate, this is where they'll fill them by nominations, yes, by party lists, which is an oxymoron. Speaker, you are a lawyer, you know. There's no concept of party list in our constitutional law.
The reason I'm holding you to this, Honorable Karoli, is that you are reading the report of the committee selectively, because the committee is saying in 88 and 89 that they agree with the report that the 2/3 gender rule be implemented through party list, if you read 88 and 89. What they are saying is overly ambitious in 92 is a proposal to implement it in this term. So the total sum of it is that we will still, if you are to go with the report, we will still have party lists that will have a top-up. That's what they are saying.
Mr. Speaker, thank you. So that I make progress on the other clauses, I will leave it here. It will suffer the same fate as BBI.
Correct. Allow him 3 more minutes.
It will suffer the same fate as BBI. Secondly, I'm very happy that this report clearly rejects the proposal to have leader of official opposition. Honorable Speaker, our constitutional architecture does not contemplate a position called the leader of opposition. If any leader of a political party wishes to lead his party in parliament, there's a pathway provided by the Constitution. They should nominate themselves, put themselves on the nomination roll, come into this house and be minority leader. Leaders of opposition, there is no way it can exist in our constitutional order. So again, we were taking people for a ride. I'm happy that is out. On political parties bill, I'm very happy that this report recommends that political parties cannot take away your election, as they have tried in the past with some of us. In Kenya, people are elected directly by the people, not by the parties. And parties are not elected in elections in Kenya. And once you are elected, even if you disagree with your party, they cannot remove you from this house. That is the law. They cannot remove you from this house. And let me put it very clearly. What we need to do is create what we call a crossbench in this house. If you go to the House of Commons today, the former leader of the Labour Party, the one who even ran for elections and lost, is no longer in the Labour Party. He's run as an independent. There's a crossbench which should be out there. Those who have not agreed with their parties or disagreed on issues and do not wish to caucus with their parties, there's a crossbench where they are free to sit. That is the practice in the Commonwealth. A political party cannot take away, they cannot overturn the will of the people after you've been elected. That is the law. But we should have gone further. They should have gone further and reviewed even Section 7, 2A and Section 7.2, subsection 3 of the Political Parties Act, where dominant political parties are putting barriers to establishment of parties that can compete with them. And when we come to discussion of the new Political Parties Amendment Bill, which is also from NADCO and which has illegalities, we will point it out. There is no requirement that my party should have 1,000 members in 25 sub-counties. Or if I have a party, I should be registered in those sub-counties. If I want to form an Omena party for Omena fishermen, I should be allowed. And a political party should be registered in not more than 72 hours. That is a practice in the Commonwealth. Not what I'm seeing the games where dominant political parties are trying to create entry barriers to new competition in the political space. These are illegalities, and there are so many others. When I read this NADCO report, I see the time is running out. I may not exhaust all of them, but I'm very happy it is meeting the same fate as BBI. Because there were a lot of illegalities on this thing. Thank you, Mr. Speaker.
Well said. Thank you. The Honorable Otiende.
Thank you, Mr. Speaker. Mr. Speaker, I want to assure this House that this report was discussed in an atmosphere of collegiality. And indeed, there are no fundamental disagreements within the committee, not even with our counterparts from the Senate, at least for the meetings we attended. It is only 3 things that we must bear in mind. One, that this NADCO report was a ceasefire document. And like any ceasefire document, it must be treated with positivity and purposiveness. Wherever it appears not to achieve what was intended, it is our collective business to ensure it does. Secondly, it was fast-tracked for obvious reasons. The Honorable Murugara and I were in the first NADCO. For reasons we don't have to discuss now, it died a natural death, and we came to NADCO 2, and now we are here. The generality of the report is to support the NADCO report. But as with everything that was fast-tracked, there are some ideas that were left inchoate. They were incomplete. The committee endeavored to complete their purposes. In some instances, we were given options, as with the 2/3 gender. The report suggested...
The Honorable Sabina Chege shall do the right thing. She will always do the right thing in the House. You'll...
Crisscrossing.
No, you can't do that. This is your 3rd term. This is your 3rd term in Parliament. Do the right thing.
It is called compounding an impropriety.
Otiende.
So I was explaining, Mr. Speaker, that in some instances it gives us two options, as with the 2/3 gender. You could say you could go for top-up, or you could create special seats, or you could do what Honorable Karoli was suggesting. So the committee settled for the top-up, and I'll talk about that. But thirdly, the committee had an eye on legality throughout, that whatever proposal is made, it must be consistent with the law. Now, with that, Mr. Speaker, I am happy to say that I associate myself with the report of the committee. My divergence is only in 3 points. The first point, Mr. Speaker, is on the proposed amendment to Article 103. That is the question, the proposal of vacation of office of a member of parliament, and the same would go for governor or county assembly, where either one resign or is deregistered from a political party, in circumstances that would then be indicated. The point here is this: our constitution now, and I put that word there myself, has provision for deeming one to have left a political party. That provision has never been implemented in the 14 years that we've had the constitution. Why? Because it requires the speaker to do something else. The speaker must trigger it by now saying that the member is deemed. And as long as you don't present a letter, the speaker, wherever convenient, will not deem you to have left. I think it has brought a very untidy situation. I believe the position should be that when I'm elected a member of parliament, as indeed, Mr. Speaker, you are elected as a member of parliament for Ugenya on MDG, there are people who elect you because of you, and there are people who elect you because of the party. If you decide that the party is no longer important enough, then you should face your electorate yourself. And that is what the proposal sought to achieve. But the committee rejected it. I am persuaded, and on this we were with Honorable TJ Kajwang, that provision should not be thrown out as the committee has proposed. It should be included so that we have some political hygiene. People don't just crisscross all over and think nothing of it. The second point, Mr. Speaker, you'll add me a little more, because you remember I had points of divergence. And so I am actually going to beyond the report that is there. But I'm only speaking to three things.
It's what you have first.
Yes. The second point is in relation to the question of Prime Minister. We pointed out there that the report uses the word Prime Minister, but everywhere else,
2 more minutes.
It is Cabinet Secretary. And so we thought that for consistency, there should be some consistency. But two things. One, some of us thought that we should go further. We should not shy away from recommending a parliamentary system, if that's what we want, and then stop at having a presidential system and just changing names. And more importantly, I also pointed out there that this is a proposal that would require a referendum, and we must just be honest with it. Thirdly is on the 2/3 gender principle. Now, this is a very delicate thing, because it's a question of achieving full representation as against the cost of representation. It's not an easy balance. And all I've pointed out there are two things. One, that as we do this, we must take the courage to go back to the people, also in a referendum. Because if you look at Article 10(2)(a), and you look at Article 255, I'm persuaded that this is also a referendum question. Also because when you increase the number of members of parliament to beyond a certain level, you are not just affecting the functions of parliament, you are affecting the functionality of parliament. So as we are taking the other fundamental question, we must be prepared to take this question also, so that Kenyans help us resolve that very delicate issue of cost versus representation. It is only on those three issues that I had a divergence with the committee. But on all the others, we are on all fours. So, Mr. Speaker, I support the report of the committee. Thank you.
The Honorable Wanjiku here. What is the point of order?
Honorable Speaker, I was considering the debate in the House as very mighty, as it is speaking on the complexity of politics in this country. And in that regard, I'm considering the House in terms of Standing Order number 35. So the House has no quorum.
Order. Order. Could you allow the member to...
I'm asking your eyes to catch the House and see that there is no quorum, so that this debate can be debated when the House is full.
Of course, we shall have quorum, and therefore I order the quorum bell to be rung for the next 5 minutes. The quorum bell to be rung, 5 minutes. Okay, the quorum bell shall be rung for 10 minutes. That is the whip. That's the whip going to whip. That's the whip. That is actually the majority whip. That's the majority whip. It is allowed. It is a very cool time for this kind of debate. Yeah, but you see also, now at this point now I can't stop, I can't stop listening to her. Ways you can unite it just prepare for her. I'm coming. You know, you're injecting nicely, so I didn't want to confuse you. You're injecting, I like the way you're injecting things. You see, these guys, because for elective, you already have 47 men, and the point comes when there are more women, you will turn it to 47 men. That was the idea. See, if you look at the materials for the constitution, for 47 you were for to bring women on board. Okay, so there was no reason to bring another. If you want to change the constitution, change it to remove the elected, make it appointed. Then make it appointed. Party man.